Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha, where on the channel our endeavor has always been not only to create legal awareness, but also to solve legal complex issues and to do it in the simplest of the ways so that it is easy for everyone to understand and comprehend it. So today, the topic that we've chosen for session is companies law in India, a journey beyond 100 years, brief introduction and aspects of litigation, wherein not only be covering the historical perspective and how the legislations came into the picture, and what do we mean by company, what are different kinds of company, and what are the landmark case laws or authorities that govern or define the same. But we will also be dealing with specific legislations and that are currently governing company and various other different kind of companies under the present regime. And joining us today on the virtual amicus is somebody who needs absolutely no introduction. He's expert in the field of company law in conversation with Mr. Gaurav Sharma, who's an advocate at Honorable Rajasthan High Court. And just to give you a brief introduction about our amicus for today's session, Mr. Gaurav Sharma has been enrolled in the Rajasthan High Court Bar Association in the year 2007 and has been a practicing lawyer since 2006 before Honorable Rajasthan High Court, Supreme Court, NCLTs, and various other forums. And his practice of law mainly includes civil law, companies law, arbitration law, as well as insolvency law. He has been representing private clients as well as public institutions like RICO, official liquidator attached to Honorable Rajasthan High Court, various insurance company, RSRTC, and Sanskrit University, and many more to the list. His particular forte is in the field of company law. So we've got hold of absolutely the right expert to the domain expert to deal and delve into the topic that we've chosen today, that is companies law. Thank you so much, sir, for taking out time, on a Friday morning and readily agreeing yes and saying yes for doing a session on the virtual amicus. Anything that you wish to say about our channel before you proceed with
Yep.
this?
It's absolutely a pleasure, Jay, to be here, and especially seeing the the host of guests that have graced this channel. I feel that this is the perfect forum, which caters to the needs of all, especially advocates and the people. So it is a pleasure to be here, and I wish you a very good, happy Navratri, and to all your audiences as well.
Grateful, sir, for all the kind words. I really so wish that we had a virtual platform like this back in the day when we were in law school, just for our help and for our guidance and support. So, sir, the stage is set. The floor is all yours. Over to you.
So the topic today is with regard to how the company law developed in India, and what is the company law? Company law in India, if seen from this perspective, is the cherished child of English parents. And our various companies law have been modeled on the English law because of the British regime, the colonial rule in India. All the companies law at various phases, at various stages, have been modeled on their parent, if you could say, about the company law, which was prevalent in the England, UK, and this is how the journey began somewhere in 1850. Before we go on this particular voyage, I would define what is company. The word company has derived from two Latin words, com and panis. Com means together, an association, and panis means to have bread. So the virtual meaning of companies comes out to be having bread together. So it was in those informal days when the adventurous merchants used to uh, take to their advantage the festivities which they attended to transact businesses. And this is how the word company came into effect. And the word company was borrowed from these informal associations to a formal the meaning, which the terminology that we assign to it today. A company under law is a corporate body, which we all know. It has a legal personality, has a status and personality distinct from its members. And this is how the company came into effect. Now, talking about the company law, the voyage of company law in India. In 1850, the first Joint Stock Companies Act came into effect. It was a skeleton of an act, not much provisions. It was just to have the companies introduced to the country, how the business model goes on the basis of a joint stock companies, and that is how 1850 has no significant effect on the economy of the country. Then there are four particular sections at different eras which are important and which had a major effect on the country's economy, social structure, and the way the law developed. So the first stage would be 1866, when 1866, for the first time, the company law got the shape and structure to affect the economy of the country. 1866, which was, of course, the British regime, it was formed, this particular act, to regulate the formation, management of the companies and to ensure that the transparency is there in their dealings. Basically, it was based on the English Companies Act, which was prevalent then in the UK, and it aimed to provide a framework for the registration and regulation of companies in India. It was in its formative years, and it did not provide for the concepts we hear today of limited liability of shareholders. The shareholders were liable for the entire liabilities if the company sinks, and their personal assets would also be, at risk at this stage of the company law. So this was had limited features in terms of the comparison with regard to the company's law, which developed over a period of more than 100 years. And it had basics with regard to rules for registration of the companies, submission of annual returns, and provisions for inspection of company records, for transparency, for dissolution of companies, how the companies would dissolve, which was not there before 1866. This was the first piece of legislation passed in India to regulate the registration and operation of uh, companies. Shareholders were fully liable for the debts of the company, meaning that if a company were liable to pay the debts, they will have to mortgage their own personal assets to clear those debts. Till the debts were cleared, they were personally liable for the liabilities of the company. So there was potentially no difference between the company and the shareholders. This made it difficult for entrepreneurs and potential investors to invest and start a new business by way of forming a company, because everybody was feeling the risk and uh, the the unlimited liability that could be fastened on them, and their personal assets were at risk. So this is how the Companies Act had this particular major drawback to say, and it also did not provide for the concept of public company. Public company, which meant that companies could not raise capital from directly from the market by issuing shares to the public. So this way, it again had a drawback that it could not raise the amount of capital that could be raised for starting a company of a bigger scale. So this limited the growth and the potential of their operations. 1866 Act also did not provide, for regulatory oversight of the companies, and the entire responsibility was on the company to provide the annual returns. There was no auditing, there was no overseeing whether the accounts are, genuine or could be altered with, and their functionings were, there was no independent body to oversee their work. So it was a major oversight while enacting this particular act. Despite these limitations, the Companies Act was an important step in the evolution of companies law in India, and particularly in the business landscape of the country. It laid the foundation of future legislations which paved the way for introduction of more comprehensive and effective laws to regulate the registration, operations, and the resolution of the.
So
This is
basically, sir, if I may ask, the first company legislation in India basically was passed in the year 1850, and it was known as the Joint Stock Companies Act, right? Hope I've got
right,
it
right.
perfect. You can.
That was 1850, but in the sense of a major act that was promulgated, which had, uh, you know, uh, codified law with regard to uh, operations. That was a very basic skeleton of a act, 1850. So,
Hmm.
in that sense, 1866 was a major act. In that sense, it was a first act in the sense of a true act, if you say. Right? Then the
Basically, with all the checks and balances.
of course, of course. So now then thereafter we come back to a stage of 1913, where again a new act replaced the Companies Act 1866. This act is known as Companies Act 1913, which was a significant improvement over 1866 Act. Was the first time new concepts were introduced like limited liability of shareholders, which I just explained while 1866 Act was being explained. So limited liability of shareholding means a greater number of entrepreneurs entering into business ventures, into companies, forming companies. So it meant that the liabilities are restricted to the amount of shareholding they hold. So say if they hold 5 lakhs of shares, their liability in case the company sinks would be limited to 5 lakhs and not beyond that, even if the liability is much higher than that. So this made it easier for entrepreneurs to raise capital and start new businesses. Then it also provided for registration, management, and dissolution. It established the registration of companies and the Indian Companies Act board to oversee the implementation of the act. Then this was in fact an independent body that was provided, seeing that earlier in 1866 there was no such independent body. So there was a check and balance in the form of this particular institution. Then inspection of company records were provided for, filing of ARs was there. Again, it was there were more comprehensive provisions, and there were penalties that were introduced for non-compliance with the act. Say if you do not file your annual return timely, then you will have to incur your further your liabilities which are provided under the act. This was the first major overhaul of the Indian Companies Act. Registration of the companies was responsible for regulation of companies and a registrar of companies was established. Registrar of companies who is responsible for the registration of the companies and maintaining the records of their, accounts, their filings, their books, their records, which are being formally filed before the registrar of companies. That way, there was an independent body, uh, much improved than what was provided earlier in 1866 Act. There was none, and then this was for the first time it was introduced, 1930. So registrar, then there was an Indian Companies Act board which was responsible for interpreting the act, which nowadays is solely the responsibility of the central government, and providing guidance to the companies like these circulars, and whatever there are difficulties in interpretation of the particular sections or compliances of the sections, for further explaining the same and for providing the rules thereof on how to comply with its provisions. Rules were introduced and for registration, management, and dissolution of companies. For registration, these three things were required. The first one was articles of association. The second was memorandum of association. Third was list of shareholders. Now, article of associations basically contain the objects of the company and how and what to do about the company. The name, the memorandum of association contained the names, the shareholding, and the persons who have subscribed as a member of the company, and so on. List of shareholders was simply the list of the shareholders with their name, addresses, and everything. This is how registration was done with these three basic documents. So rules for management were provided, which said that there would be meetings that would be conducted and how those meetings would be conducted, how voting would be done. Those things were provided, like if say there are 10 people in the management and only 8 people attend those meetings on a particular day, then how the voting would be done, what would be the majority of voting, 8 people present, and uh, the majority of 8, say 5 people have voted against a particular resolution, so that would count as the uh, resolution of that particular meeting. As a uh, these were the rules, and it would also provide for raising of your hand to vote, or by other means. And it also provided for maintaining of the records, minutes of meetings of a particular meeting, and submitting it regularly to the ROC, Registrar of Companies. These were the things which were with regard to the management, and they were provided for appointment of auditors. This was a major thing. Auditors had an independent, lookout, oversight, or overseeing the work of the company, and they can report that these are the glitches in their internal accounting system. These are the things which have, escaped the eyes of the naked eye of seeing that particular accounts, the profits. They have inflated the profits. They have, shown fake records of the assets, and likewise the auditors were introduced, and those auditors had a valuable, input with regard to the uh, overall overseeing of the company's function.
So,
Then there was submission.
one quick question that I had. So, is there any statutory requirement for the appointment of an auditor, as in a particular experience or expertise, or it could be any auditor that a company could rope in?
At that particular stage in 1930,
Kind of, yes.
the professionals who were, CAs and CAs, they were appointed as auditors. So there were no particular examination for being an auditor, or particular, screening of who could be the auditor. The auditors could be any professional. in the market. But it should be an independent, no relation with the company. Then inspection of company records were provided anytime the company's records could be inspected. And then provisions for dissolution of companies was provided a process including submitting a notice of dissolution to registrar of companies and obtaining the approval of the Indian Companies Act Board, which was instituted to regulate and to responsible for interpreting the sections of the provisions of law. It also provided for distribution of assets at the time of dissolution. How it would be distributed amongst the shareholders, how it would be distributed amongst the secured creditors and other unsecured creditors and other stakeholders. It naturally helped and played a major role in the growth and development of the Indian economy and business landscape. So this is how 1913 was a uh, major act in the sense that it introduced new concepts to the business landscape of the country and how it affected those particular times. Then we move on to 1956 Act. 1956 Act was promulgated somewhere around 1957. And it was a major overhaul of 1938. And it was based on UK Companies Act 1948. Then 1956 Act was provided for three new companies: public company, which was not there previously, private companies, and companies limited by guarantee. So central government as a regulator of companies laid down rules for management of the companies, including rules for holding meetings and maintaining records, appointment of auditors, annual reports, returns, and inspection of company records for ensuring compliance of the provisions of the Act, penalties for non-compliance with the Act, and dissolution. Further, 1956 Act came into effect on April 1st, 1957, streamlined the regulation of companies in India, provided for appointment of company secretary, who in turn is responsible for ensuring that the company complies with the legal and statutory requirements. So a particular shareholding of a company, there was a limit. Say it is a 1 CR company, according to its turnover or share capital. Then a company secretary is mandatory to be kept with that particular company, who would oversee and who would be responsible for any glitch that may come up in the company's records. So the compliances would be done by in-house company secretary. Then one more important feature is concept of the depository receipts. This allowed foreign companies to list their shares on Indian stock exchanges through depository receipts, which are issued by a domestic depository in lieu of the underlying shares. This provision was aimed at attracting foreign investments into India and promoting the development of the Indian capital market. It also introduced provisions of winding up, which was not there previously, and dissolution of companies. So winding up is a chapter in itself, which is takes years and years. Uh, Practically, it took years and years to even today we are facing certain matters under the 1956 Act, which are continuing in the High Courts, and there was much litigation under the winding up process, and then after distribution of the assets, the dissolution took place. Dissolution could be recalled if, in case there was a limitation period, of course, if some stakeholder finds that this particular dissolution was done behind their back and there was some undone business of the company which ought to be reviewed. Then we come to 2013 Act, which is today's Act. and the we are of course uh, you know governed by this act today, and the concept of NCLTs and NCLATs were introduced. This was pursuant to a commission called Dr. J. Irani. J. Irani he, was a director in Tata Sons, and he was appointed as the chairman of this expert committee. He submitted his particular committee report, and this was because of Satyam scam. There was a Satyam scam which we have all heard. The Satyam scam was a scam where the particular director of that company, Raju Lingam, if you recall, what he did was he uh, showed his shares value much higher than they were there. And on the basis of those inflated shares, he sold those particular shares in the market. And uh, from that money, they bought properties. And then the trail was discovered after the property market in Hyderabad crashed. The trail went on to this Satyam scam, where it was a 7,000 crore scam at that particular point. So it also influenced the way the JJ committee, the expert committee, which was formed to formulate this 2013 Act, and there were stringent provisions that were provided in the 2013 Act because of Satyam scam and the committee report that governs the particular 2013 Act. So one unique feature that was before that, the recommendation of JJ committee finally culminated in the form of Companies Act 2013 with effect from 29th of August 2013, and it applies to the whole of India. One unique feature is that the government has retained the power to amend by Ministry of Corporate Affairs. So normally what we do is that whatever amendments is required in a particular legislation, we go to legislators. It has to be passed by both houses and then it becomes law. Now here, the unique feature is the Ministry of Corporate Affairs can amend the provisions. And Companies Act is not a standalone piece of legislation, but a complete ecosystem in the sense that there are every chapter has a corresponding rules, regulations. So every section, every chapter, every act, every particular topic has to be read along with its corresponding rules and regulations. So they act as supplementary and they act as extension of that particular topic or particular chapter. So new concepts were also introduced, like there are concepts of women directors. Now every company, listed company, has to have a women director. Every company which has a particular shareholding, there is a limit that has been provided that that has to have a woman director. So women directors have not been defined as such, but women directors needs to be inducted in particular companies. In a public company also, you need to have a woman director, at least one. So if we go through that particular section of the Companies Act, which provides for the woman director, it is section 149(1) of the Companies Act. It is mandatory to have at least one woman director on the board of following classes of companies: every listed company, every other public company, having a paid up share capital of 100 crore rupees or more, or turnover of 300 crore rupees or more. This is with regard to 3 consecutive financial years. Uh, this particular turnover, that is 300 crore rupees. So this is how this new concept of women directors was introduced. Then this corporate social responsibility concept was created. This was already there, like the Tatas, the Birlas, they used to spend much on the social causes at their particular times before CSR was introduced formally in the form of Companies Act. But now the government saw that it is the need of the hour to, introduce CSR, and the company should be responsible because they are taking much from the society, and what are they giving in return? So CSR concept was introduced.
Sir, what kind of corporate social responsibility does a company needs to undertake as per the requirements of the act? Is it a community service? Is it endowment, donation? What kind of responsibility does a company has to?
So, for a particular cause, now again we need to see are the rules, the regulations, the circulars of the Ministry of Corporate Affairs to further see what are the causes that can be invested for. So basically, say if pollution is there, planting of trees is there, the corresponding duty. So if there are children who are deprived of education, you are adopting a particular uh, a village, and you are donating money, or you are creating the infrastructure for that particular village, for that particular thing. All the social causes which can be brought, you know, including electrification, everything which was the primary duty of a government, which is the primary duty of a government under the Constitution of India. All those social causes can be taken up, and particular section is 135 of the Companies Act, which provides that it is mandatory for certain type of companies to have the CSR committees. The CSR committees includes at least three directors, and out of these three directors, at least one independent director, and uh, these CSR committees have to overlook for the uh, social work, social responsibility of the company. And the companies have also been further defined to be the companies having net worth of rupees 500 crore or more, or turnover of rupees 1000 crore or more, or a net profit of rupees 5 crore or more during the three financial consecutive years. So this is how the CSR came into effect. Now, the what would be the percentage? You may ask me further. What would be the percentage of the CSR responsibility? So it is further defined that the board of companies are required to ensure that the company spend at least 2% of the average net profit of the company made during the three immediately preceding financial years. And one aspect we missed out is that at least one director shall be independent director. The concept of independent director has also been introduced in this act, in this particular act, and this is with regard to introducing a director having no connections with the company, no profits that goes to his coffers, and independent director has been defined under section 149, I guess, in which an independent director has no relation with the company except remuneration that would be also restricted to a certain percentage of his total income. So he means a director other than a managing director, a full-time director, or a nominee director, who, in the opinion of the board, has integrity and possesses relevant expertise and experience. Say, if the company is dealing in a particular business which needs a certain kind of expertise. So, a person having integrity, having a name in a particular field, can be brought in as an independent director, having a limited, liability to the company in the form of remuneration, who was not associated with the promoter of the company or with the holding subsidiary or associate company. So this is how the concept of independent director has been introduced, right? It is a very detailed section and a detailed meaning to the independent director has been assigned. Now, coming back to the act, then it also provided for class action suits. So if the members or the depositors of the company finds that the management of the company is functioning in a way causing loss to the depositors or the members or the company, they can file a class action suit before the NCLTs. NCLTs are established all over India, National Company Law Tribunal. So this is how the class action suits were provided. Then there were one-person companies were introduced, small companies concept has been introduced, associate companies have been introduced. Now, preempting your question, I would come to their meanings. What would be a one-person company? As the name suggests, a one-person company would be a person, one person subscribing to the company. That is only one member. He can start the company. But then there is a limit, say, when he has to convert that company into a private or public company if during 3 years the profit making is more or the investment is more than a particularly prescribed limit under the Companies Act. Similarly, there are small companies where the capital has been defined that this above this capital, it would not be a small company. And then associate companies have been provided where a particular company having control over the board of directors of a particular company and having the power to remove the directors, having the power to decision making of a particular company, then it would be called an associate company, which is not holding and subsidiary company. Holding and subsidiary companies are a different concept in themselves. Holding companies are who holds stakes in the subsidiary company where in the form of assets or shareholding or the board of directors. And whereas associate company is with regard to decision making of that particular, limited to that. Then this dormant company concept is also very important to understand. This dormant company concept has been developed for the first time, wherein a company can apply to the registrar to get itself declared as dormant company. This concept has been provided under Section 455, where this company is formed and registered under the Act for a future project or to hold an asset or intellectual property and has no significant accounting transaction. Significant accounting transaction has been further defined, and which company or an inactive company may make an application to the registrar in such a manner as prescribed the forms that have been prescribed under the Companies Act. And then these significant accounting transactions have been defined, wherein the transactions like paying fees to buy a company to the registrar to fulfill the requirement of this act, allotment of shares are not there, payments for maintenance of its officer records are not. These are the significant accounting transactions which have not taken place. And in those cases, the company can declare itself dormant company, and the liabilities, the responsibilities under the act are not fastened on the government companies like filing of the annual returns time to time or all these formalities which are there for the other companies. Dormant companies enjoy the status of remaining dormant till they want, right? So moving on, then this fraud has been defined for the first time in the Companies Act, and the fraud has been defined in Section 447. Reporting of fraud by the auditor to central government in case amounts exceeds the limit of 1 CR or more, and lower to the audit committee. There were audit committees also formed under the Act. Now the public companies can get their securities listed in the foreign jurisdiction. Penalties are much higher. Penalties are also imposed on companies on the basis of their size, Like if the size of the company, it is a small company, the size of the penalty also reduces accordingly. Then there are new provisions, including that of independent directors, which we just discussed, the CSR, which we discussed. Significant changes to the rules for the formation, management, and dissolution of companies were there. One unique feature of this 2013 Act was one person company, which was unheard till now. And this has only one member. As I said, this allows for a single person to own and run a company, making it easier for entrepreneurs. This is the logic behind it, making it easier for entrepreneurs to start and run their own businesses. Then uh, another important feature of 2013 Act is the introduction of independent directors we discussed. Then who have the oversight and ensure the interest of the shareholders are protected. They are not associated with the management or control of the companies. This was the objective behind creating the independent directors. Now, NCLTs are the quasi-judicial bodies responsible for resolving the disputes. If we go stage-wise, there are, you know, 5 forums under the Companies Act. One is with regard to registrar of companies, then a regional director, then the central government, which are things which could be, overseen by these administrative executive side. Then the judicial side, we have special courts established under the Act, under which there are penalties or the imprisonment is provided, where which is more than 2 years. They would be, tried by special courts, which are district courts assigned under the by the central government, that these would be the special courts. Now, thereafter, NCLT is there. NCLT, which deals with the uh, host of things from the formation till the dissolution. Basic litigation involves operation and mismanagement, uh, mergers, demergers, which is a chapter in itself. Then we have winding up issues, where the company goes into liquidation, and then the management and the other officers who are in default can be prosecuted. Then thereafter, shareholding disputes are there some days. Those are the things, and many more litigation. Now the NCLT have been empowered to decide matters related to all these things which I just briefed you, and there are simplified procedure for now company registration, company management, and there's one more thing. Uh, Everything has been done online. Now at Manesar, there is a big setup of the central government, the Ministry of Corporate Affairs, where every filing has to be done to that particular softwares and the things they have developed with regard to online filings and online. This ensures the transparency as well. Now, this has been widely welcomed by the business community, being innovative and being the catering to the needs of the society. And some major developments have been taking place since the enactment of the Act. One major fact is the IBC, Insolvency and Bankruptcy Code, which basically consolidates the existing framework of insolvency and bankruptcy laws that were prevalent in India. So, Section 304 to 323, which were regard to voluntary winding up, where the company would voluntarily get itself wound up through the NCLT were omitted because of the coming of IBC. IBC, you have done, uh, you know, uh, there are enough material on IBC, which is a chapter separate from ours. Then NCLT and NCLT have been operational. Company law boards, company courts in the form of high courts, and BIFRs, which dealt with the um, insolvent companies, and to resurrect them, there was a procedure under BIFRs that has been abolished after NCLT. Now everything has been assumed. The entire power and the adjudicatory powers have been given to NCLTs. There is a serious fraud investigating office, which has been established under the statute. Now, the Finance Act has been introduced, and on this Finance Act 2017 amended Section 182 of the Act, which related to the political contribution and abolished limit on amount of political contribution by the companies. This act also has a provision for political contribution by companies. Then National Financial Reporting Authority has been established, notified on 1st October 2018, has powers in issuing authoritative pronouncements and also in regulating and the audit profession. This National Financial Reporting Authority. So what happened was, there were certain cases where even auditors like Price Waterhouse had uh, changed the way how auditors are seen, and these National Financial Reporting Authority have a further overseeing of these audit functions that were carried out by the independent auditors. Online compliance monitoring and e-adjudication launched by Ministry of Corporate Affairs somewhere uh, exactly on 6th of November 2019. It works on AI. We talk about AI day in, day out. Now AI has been introduced. It automatically detects the non-compliance by companies and digitally sends show cause notice to the defaulting companies, which is a big step in the evolution of how AI has been the part of Companies Act. Then the defaulting company is required to submit its reply within 15 days digitally via MCA portal that I was talking about has been developed. Now, uh, there are assessment tests for being an independent director. There are particular rules of 2019, which require particular standards that has to be achieved by the independent director, and there are tests with regard to the becoming an independent director. Measures have been taken in the light of COVID-19. During COVID-19, everybody was locked down and economy was at its lowest. So measures were taken. The compliances were relaxed. The times were extended to do the needful, like providing the annual returns and everything. And the concept of AGMs and EGMs through virtual conference was introduced, audio visual methods were introduced so that things would be eased out and the things would be checked, and the COVID-19 does not spread during that period. Now, we were talking about all these things. Anything that you think that I need to further explain, or we should go for the question and answer sessions?
Sir, I think we can proceed with the Q&A segment if you're ready.
Right.
So, sir, talking about you've already discussed corporate social responsibility in great detail. You've also talked about different kinds and types of company, one person company, dormant company. Now, talking about company being a legal person, and you, as you rightly mentioned out that uh, the doctrine of lifting of the corporate wheel is an exception to the concept of a company being a separate juristic entity. So, on the other hand, the company is a separate juristic entity. On the other hand, there is a concept of lifting of the wheel, sir. So, if you could slightly throw some light on that, and under what circumstances can this doctrine be invoked, and how, in what circumstances can piercing of the corporate wheel takes place, sir?
So basically, there was a case, a celebrated case with the title Salman and Salman Company, wherein all the debenture holders were the family members of Salman, or the Salman was owning that particular company. So there were certain unsecured creditors who said there is no difference between the company. This case dates back to 1800s, 1897 or something. So they say that uh, this is virtually Salman. So why, when the liabilities are much higher and the assets are much limited, why the entire assets should go to the debenture holder? Why it should not come to the unsecured debtor? So they approach the particular forum available at that particular point, and the court said no. There is a distinction. There is a distinction in the sense that the company is different from the members of the company. It has a separate and distinct legal identity, and you cannot mix two things. So they the company enjoys its separate identity and has a recognized um, feature to say that it is independent of its members, and so the case failed of the unsecured creditors. So this is how the court separated from the company the members of the company. Now, when you move on to the concept of lifting the wheel of this particular country, so this was developed over the period of times, and when people used to, there were certain cases where people were misusing the concept of company to do frauds and do things to justify their illegal acts. So there is a celebrated case that I would like to refer. This was Vodafone. This is a recent case, Vodafone International Company, if you recall, wherein Vodafone purchased the Indian mobile business of Hutchison. So uh, Hutchison said, sorry, Hutchison had withheld certain taxes. So the liability, income tax authority said that these taxes which were withheld by Hutchison, now since the management is almost the same, this withholding of the taxes is the liability of the Vodafone company. Vodafone company went to Bombay High Court, which was the forum at that particular period. Bombay High Court said, no, you have to pay the income tax authorities the withheld taxes, and you are the same. They approached the Supreme Court. And it was a huge penalty, more than 5,000 CRs, 110 billion taxation. So they went to the Supreme Court, and the Supreme Court said, no, there is a difference between the earlier Hutchison and the things which were done by that particular management and the Vodafone. And during the course of that particular judgment, the court came to certain uh, concepts when this corporate wheel can be lifted. So those things have to be, I'll just brief you out those 4 points on which the court had said that 4 or 5 points it can be. 6 factors were different. They said that where the transfer is bogus and when corporate will can be lifted. The first one was the concept has to be seen from the particular investment that has been done. Then the second concept was duration of time during within the holding infrastructure existed. Then the third one was the period of business operation in India. The fourth one was the generation of taxable revenues in India. And fifth one was hiring of uh, the exit. When was the exit of that particular business took place, and whether the continuity of business is still there after the existing of the particular management. So these were the 4 5 factors which was enlisted by the Supreme Court in the order from how this, and this is reported case, a celebrated case which is followed till date. Now, there are certain special privileges to the company. Those special privileges are being misused by the management to uh, gain unlawfully. In those cases, the corporate veil is being lifted to see whether it is the company or the people who are behind it, whether management, whether officers, whether employees, who is behind this particular fraud. So this is the concept of lifting the veil.
So now going ahead with our next question, often the company is defined as an artificial person created by law, having a separate legal entity. Now there are two keywords that are used in the definition under the Companies Act, under the current statutory framework that we have. A separate entity with a perpetual succession and common seal. Now, so does perpetual succession mean that once the company is created by a process of law, it can only be end by it? And does it mean that how the members may transfer and then how the successors will come into the picture once the transferee or the member passes away?
So for this, we need to know who are the members of the company.
Okay, okay.
So members are synonyms to the shareholders of the company, right? So shareholders or the members of the company are the people who have formed this company. So this particular doubt or the question comes into play in seeing the company as the shareholders or the members as the company, right? So basically, they are two different things. Members may come, members may go, but the company would still perpetuate. This is the perpetual succession of the company because shareholding is transferable. Members may choose to sell their shares and exit, but the company can go on. And this concept was, introduced so that the business that lies behind the company. There are many stakeholders. In fact, the economy is dependent on a particular company. So the company should have a perpetual succession rather than the members. Members are natural persons who have their, by way of lifespan or by way of their particular self-interest, they may have to exist. So
And
that
common
is
seal would be the seal of the company.
company.
Signature would be.
It is a way of like you have your unique thumb impression.
Correct.
So it is how pharmacy does it.
Very well, sir. So now that we've discussed what a one-person company is, what is a dormant company, key managerial person, then we've also delved into corporate social responsibility, talking about company as a legal person. Then we've also dealt with the landmark ruling, the authority, as you rightly pointed out in the case of Salmon versus Salmon, the company limited case. Now, sir, lastly, to conclude, if you could delve into various aspects of litigation in the Companies Act. Now, you yourself are a successful practitioner who's developed a successful practitioner, somebody
Right.
who's been inspiration to me and many in the field of company law. What would be your piece of advice to all the young lawyers, law students who wish to build a successful career in company law in the present framework and regime?
So under the Companies Act 2013, apart from advocates, company secretaries, CAs, have also been, allowed to appear before the NCLTs, being the tribunals, and the NCLATs, which are the appellate tribunal. Now, NCLT is the basic court, basic tribunal, which takes care of the litigation part, major litigation part of the Companies Act, under the Companies Act. And there is a appellate tribunal, NCLATs, appellate tribunals. Then the final appeal is before the Supreme Court. So basically, if the young lawyer who wants to start his practice in companies law, he needs to, as in all fields, he has to join a good senior having a background of companies law, who is regularly appearing there and observe in the. He should sit there in the NCLTs and watch over the cases. Everything is reported today. NCLT judgments are there, NCLT judgments are there, and we are hearing only the big cases like Mistry and Tata Sons and these cases. There are many resources online which are available for the. So basically, if you want to specialize, you need to, like if you want to go into mergers and demergers, you need to join a particular firm which is dealing with those mergers and demergers, specialized on that, on those lines. And it is a very lucrative line of work for the people who wants to work under the company's law. And apart from this, the regular litigation, it is, you cannot count on your fingers. There are so many aspects, so many things which you could observe only while you attend those courts. So I would advise, this would be my, because I feel for every young lawyer who comes to the profession and who wants to, you know, do something. Now, this particular field, there is less congestion also. So people should specialize, and who are hardworking. Hardworking is required everywhere, every field. But here, because of less congestion, and in fact, if you will observe in the NCNTs, lawyers from outside state also are coming here, just because people they are more approachable, VCs are available, and they are more specialized. So it is better if you want to do it, go in metro cities or somewhere where the company law work is abundant, like say Delhi, if you can afford that. And if you cannot, you can start with your own state, and so this way you can.
So to all the viewers who are watching, two key takeaways has been pointed by Sir, that if you want to wish to build a career in corporate or transactional law, then you have to join a law firm that is specifically specializing in that. But if you want to join the bar, litigate, or get into litigation, then you have to join a chamber or a council who is specializing in company law. And then regular visits to the National Company Law Tribunal, which is a quasi-judicial authority, as well as NCLAT, which is the appellate authority, would you would get a better hang of what company law is all about when you see practical application of the law, than just to go through all those lectures that you read. Because unfortunately, we don't have a lot of lectures on how to build a career in company law per se. So, sir, lastly, any parting words from your end before we wrap this session up? Um,
Sorry.
no
Uh,
problem.
so I would say to all your viewers that this jazz endeavor and this particular, virtual amicus, I have personally gone through many of its chapters, and they are, you know, something very innovative, something very impactful, something which is, have a very significant influence in uh, paving the way forward for legal professionals. And I, I give you my best of luck for your future endeavors, and I wish this thing spreads like wildfire.
Well, thank you so much, sir, for all your kind words. What a wonderful session it was. We had an intellectual giant on our channel who discussed company law in great detail, gave us a historical perspective from the very first legislation in India till the recent legislation that governs company law in India. I'm very grateful to you, sir, for taking our time for doing this. It was a very, very important topic. Unfortunately, not dealt by anybody in the last 3 years. So I'm glad that we could catch hold of you. We roped in your expertise for this. To all the viewers who are watching, please, our email is mentioned on the channel. In case if you still have queries, feel free to write to us. We'll be more than happy to forward the same to our Amicus for today's session. So next episode is on its way. It's goodbye for now. Thank you so much, sir. Once again.
Thank you, my pleasure.